Oh, okay.
I emailed like 4 different emails with everything I believe that's on that.
Okay.
So many.
What about Allison Jones? Is she
Didn't
see any on her?
yet,
Okay.
and I thought I could look again. But I don't know what all you can hear on his case. So I just thought I'd just
Okay.
bring the whole thing. to
Great.
you.
Thank you.
I'm not a fan of the way he did it. Because it's all one file with 200 pages and all the exhibits are in there.
So they're not separately
They're not
saved.
separated.
All right.
Yes.
That's terrible.
Good morning.
All right, I've got a couple of cases that are going to go very quickly. They're uncontested, so I'm going to take those up first, and then I'll come back to the lengthier stuff. On the first case, Ms. Nguyen, if you would please raise your right hand to be sworn. Do you solemnly swear or affirm the testimony that you're going to give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, thank you. You may put your hand down. Ms. Nguyen, do you know what to say in order for me to grant the divorce, or do you need me to ask you questions?
Can you repeat it? I'm sorry.
Yes, do you know the testimony that you need to give for me to grant the divorce? Do you have that written down, or do you need me to ask you questions?
I have it written down.
Okay, go ahead.
Yes. May I read it?
Yes, ma'am, you may begin.
Your Honor, my name is Huyen Phương Nguyen. I filed this suit for divorce from my spouse, Tony Quang Nguyen. At the time I filed for the divorce, I have lived in Texas for at least last 6 months and in Fort Bend County for at least 90 days. I'm asking for a divorce because our marriage has become unworkable and there is no reasonable expectation that we will get back together. My spouse and I do not have any children together who are under 18 or still in high school. We were married on October 9, 2013. Neither spouse in this marriage is pregnant now, and then neither spouse had children with anyone else during this marriage. There has been no family violence during this lawsuit or during 2 years period, the filing of this lawsuit. I ask that our property and debts be divided as set out in the decree of divorce I have presented to the court. And I believe this division is fair to both me and my spouse. I respectfully ask the court to grant my divorce. That's all I have, Your Honor.
Thank you, Ms. Nguyen. The court has reviewed your paperwork. Everything is in order. You did a good job on your paperwork. I'm approving the divorce and or granting the divorce and approving the agreements that you've reached with your spouse. And I've signed that divorce decree. You can get a copy of the order from the district clerk's office here in Fort Bend County.
Thank you, Judge.
You're welcome. Thank you.
So, so my part is done.
Yes, ma'am. You may sign off.
Thank you. Have a good
Have
day.
a good day. The next case I have is Mr. and Miss Alvarez.
Yes.
You both here?
Yes, sir. Yes, sir.
Okay. So on this case, there was a problem with the waiver because it was signed before the petition was filed. But because Moises is here, that fixes that problem. The but there's another problem, and that is, there's essentially 3 steps to getting a divorce. One is filing a lawsuit saying I want a divorce. The second step is getting the person served or having them sign a waiver or appear in court. And those first 2 steps out of the 3 steps are done correctly. The problem we have is the final step, which is the document that I need, is called a final decree of divorce.
Mhm.
And that document hasn't been filed yet. So do you have that, Ms. Alvarez? Do you have the final decree that you and your spouse
Ye-
have signed, or no?
It was in the papers.
So
That I
there was
thought that we signed. I thought that we signed all the papers.
No, you did file what's called a marital settlement agreement, which is kind of the agreement the 2 of you have.
Mhm.
And that's great, but you've got to have a decree of divorce, which is a document, it's an order that the judge signs that actually divorces you. And
Right.
it's gonna be like probably 7 or 8 pages, but that's the document that's missing. So I don't know if you and if both of y'all live close to the courthouse. If you do, you're more than welcome to come down here today, because we have the form on the 2nd floor of the courthouse. And y'all could get that form, and then we can either attach your marital settlement agreement to it and incorporate it, or you can add your agreement into that decree, and so that we can finish your case today. The other option
Okay.
is, if you don't live close to the courthouse, or it's not convenient for you to come in today, is just get on texaslawhelp.org or get on some website or wherever you got your forms and
Mhm.
get a final decree of divorce. And you need to both sign that and then file that with the court. Once that's done, it should be, 5 minutes in front of the judge, and you'll be ready to go. So that's the only document I'm missing.
Okay. I know that I had it in the papers. I guess I must have not turned that one in. So because we both signed everything.
My
So if I
clerk's
bring
saying-
it,
My clerk's saying that she's, is that the marital settlement agreement, or is that the decree? All right, hold on. She's saying she found a decree. Give me 1 second. Let me pull your
okay,
file.
yeah, because I was like, I know I believe I turned everything in.
Okay. All right. Yeah, I think maybe our notes were a little off, because the decree that you filed has got I don't know where you got the form, but it's missing a lot of stuff that is required by law to be in a decree. So I don't know if you kind of cut some stuff out of there, or if it's just the form you got was not specific for the state of Texas.
Okay,
But so yeah,
so we need to,
yeah, I think that there's a bunch of stuff that it's going to be too much for me to actually insert. So I think the best thing to do would either be to come in and get and I can write the forms that you need down, so you can get those and just fill them out.
okay,
Or I can just give them to you today if you can't come in today, and y'all can get the form and just fill it out, because it's just, there's too much missing on it.
okay.
So do you want to come in, or do you want to,
I can come and get the form, and then we can get it signed and try
Okay.
to, yeah,
Yeah, if you
I can come up to get the form. I don't know. I don't believe, I'm not sure if he can come, but if I can get him just signed and notarized, then I can bring it back, right?
yeah, it doesn't even have to be notarized. This one just
Oh, it
needs to
doesn't have to be
signed.
notarized? Okay. Yeah,
Yeah, we can do
get
that.
it.
I'll be here all day. So why don't you just, if you want, you can come up to the 3rd floor to the 387th District Court. And,
Okay.
and I'll write down the forms that you need so that you can go downstairs and get those, and then you can get them filled out and signed.
Okay, thank you.
Thanks, Ms. Alvarez.
Is that it?
Yes, sir. She's going to bring you the paperwork so for you to sign, and then she'll come back and I'll be able to finish the case. Because if you sign off on the paperwork, that tells me that you agree to everything. And,
Right.
and so by appearing today, that fixes the problem with your waiver. So I'm going to make a docket entry. You appear today. And if you sign this final decree, I'm going to divorce y'all today. If you don't sign it, then she's going to have to schedule a new date for you to come in and y'all can do it by Zoom. Okay?
Okay. What was that paper that she needed? Decree
It's
about
called
what?
it's called a final decree of divorce.
Final
and
decree of divorce. All right.
Yeah, she's going to pick it up. It's going to have a couple of attachments like a possession order and some things like that. But you'll just need to sign the last page of the decree. And if you do that, we'll be able to finish your case today. Okay?
Okay, boss. Thank you.
Thank you. All right. So I have Ms. Jones and Mr. Zachariah. I know y'all announced anywhere from 30 minutes to an hour and a half. And then I have Mr. White.
I don't want to.
Mr. White, how long do you anticipate for your hearing? Oh, he's still connecting. Mr. White, I don't know if you can hear me because it shows you're still connecting audio. White, since Ms. Moreno has to check in with another court at 10, I'm going to hear y'all as soon as she gets into the docket call, but I'm going to take, looks like I've got about 30 minutes. I'm going to take this other case up and go ahead and do that case before I take up your case, but we will hear you today, Mr. White. I know you've been reset.
Yes, please. Thank you.
Okay. And I'm going to get the record set up for y'all in this other case.
Thank you, Your Honor.
Ms. Jones, did you have any exhibits? The court reporter brought me some from Mr. Zachariah. I didn't know if you had any today or not.
I did, Your Honor, and we filed those with the court reporter yesterday.
Okay. And was that emailed to her?
Water would be good. Water bottle.
It was, Your Honor.
Okay. I can get those. Let me just do that real quick.
Water bottle. Okay. No, ma'am. Water's fine.
Ms. Jones,
Thank
I'm
you.
not seeing them in the 387th exhibit email. Can you verify where you sent them?
Yes,
We'll get them, but,
yes, Your Honor. Ms. Cook, can you tell us where we sent them? We'll do that right now. Your Honor, they were sent to 387 exhibits.
I got them. It's under Lisa Cook.
Yes, thank you. Oh, thank you, Judge Bell. I'm so glad you caught that. I'm glad I used her name.
Yeah, once you
My,
use the name,
my fault.
you did it correctly. The cause number's in there. I just hadn't searched it yet, but normally I can find them. But I see them right there. So let me download these real quick and then we'll be ready to go.
Could you go in my briefcase and pull out my file?
Okay, I'm just about ready. I printed up Ms. Jones's exhibit list for those three motions, and the bailiff's going to get those. While he's doing that, Ms. Moreno, I know you said you had a 10 o'clock docket call.
Yes, I do, Judge. I'll be checking in with them shortly. I apologize for taking so long. I tried to copy and paste your Zoom ID and it didn't work, so I had to go find out what the Zoom ID was again.
Sure. Mr. White, do you have a time announcement on how long you think your motion is going to take?
I think he's connecting to the audio.
Yeah, it's been saying that for a while, but I thought I heard him earlier. Ms. Moreno, do you have an idea on how long you anticipate for the hearing?
I don't remember what his previous time announcement was. It's been a while.
Okay. All right. Well, what I'm going to do is I'm going to hear this other case first, and then I'll take y'all up next. I know that y'all been reset once before, so we're going to get the case heard today.
So I'll check in back and forth between here and the 505th. I was court appointed on a protective order. And so that's what's set at 10 o'clock. So I don't know if they're gonna hear us at 10 or if they're gonna push us to later in the afternoon, but I'll try to figure that out when I check in.
Okay, thank you. And we'll get you heard today. I'm just not sure when yet. Because I think this other case probably gonna take a little longer than 30 minutes, but we'll see. Sometimes they go quicker than we anticipate. Okay,
Thank you, Judge.
thank you.
Are all the discovery issues worked out?
Okay, any preliminary matters that we need to address from either side before we get on the record and get started? Ms. Jones, to you
No,
first.
sir.
Okay, Mr. Zachariah, any preliminary matters we need to address before I get on the record and we get started?
No, Judge.
Okay.
And Judge, I just wanted to announce that Mr. Eric Schmidt, who's a co-counsel in this case, is here as well. So that the
Okay.
court-
Good morning, Mr. Schmidt.
Good morning, sir. Good to see you, Judge.
Good seeing you. This court's on the record in cause number 21 DCV 281100 in the matter of the marriage of Seema Jabin and Imtiaz Ahmed. Counsel, if you would please each identify yourselves and the party that you represent, beginning with petitioner's counsel.
Good morning, Your Honor. I'm Allison Jones. I'm here on behalf of petitioner Seema Jabin.
Ali Zakaria, Your Honor, here for respondent Dr. Imtiaz Ahmed, and with me is Mr. Eric Schmidt, my co-counsel.
Yes, Your Honor. Full name for the record is Christopher Eric Schmidt, and I am co-counsel with Attorney Zakaria representing Mr. Ahmed.
All right, thank you. And make sure that, Mr. Zachariah, make sure you keep your voice up. You may be the furthest one away from the mic, but I was having a little bit of trouble hearing you, and I want to make sure we get a good record today. So if you can, please make sure you project your voice into the microphone.
Will do, Your Honor.
Thank you. Now, there's several motions that I have set for today. It appears that beginning with petitioners, Ms. Jones, you've got a motion for audit. Is that correct?
I do, Your Honor.
And then Mr. Zachariah, you have three motions, a motion on a second motion to compel, a motion to modify temporary orders, which you may both actually have requests there, I'm not sure. And then a motion to add or reset mediation and for continuance. Is that all that we have set today?
Yes, Judge. So I want to start by saying that Ms. Jones has produced a substantial number of documents yesterday. I don't know if that in fact satisfies my motion to compel or not, but rather than waste court's time on something that may have already been complied with, I'm going to pass it for now and reset it for another day.
Okay. All right. We're going to go ahead then. I'll make a docket entry that we're passing the motion to compel. And then Mr. Zachary, if you need to reschedule it, then you by all means just get with Ms. Jones and y'all reschedule it. Hopefully, if there's something missing, you can just contact her and y'all can work it out and get those documents together. But I appreciate y'all working together on that. So then that just leaves the motion to modify temporary orders and the motion to reschedule mediation and motion for continuance for you, Mr. Zachary.
And Your Honor,
Yes,
I
Judge, and we-
apologize for interrupting, but I didn't get notice of that. Please go ahead, Mr. Zachariah. I interrupted you.
And we also have respondents' motion for audit, Your Honor.
Correct. So Ms. Jones, what is the notice issue? Which motion is that on?
The notice issue I got from Mr. Zachariah said on December 1st, they were going to hear the motion to compel discovery, the motion to modify temporary orders, and the motion for audit. And while we were waiting for you, I did call Mr. Zachariah's office and tell him of the potential problem because maybe I had missed it or maybe it gone to junk or spam. And I said, if you produce it, then obviously I'm not going to object to it. Anyone can, miss this statement, but I don't see it. And the date that he gave me notice was November 23rd of 21, and it clearly sets out the three motions he's going to hear today, and those are the three that I prepared for. I have not really prepared for the other two, although I'm not saying that I won't reset mediation. I don't mind resetting it for beginning of January. I know Mr. Zachariah was saying February. I don't want to delay it, but I just wanted you to know we don't have notice of his motion for continuance at this time, and it may be premature to hear the motion for continuance at this time.
Well, I know
Judge,
y'all are set for January 20th, correct?
Correct.
Yes, Judge. Judge, first of all, I want to go to mediation tomorrow if possible, but it's Ms. Jones and her clients that skipped the mediation that was scheduled for November the 5th, which has caused my need to seek from the court a continuance. So I think it doesn't make sense in this case for Ms. Jones to skip mediation and then say that there's no need for a continuance in this case, even though the trial is set for January the 20th, and we can't get a mediator for the month of December for obvious reasons. The few mediators that we have talked about are not available till the end of January or maybe even February. I like to go to mediation tomorrow if possible, Judge.
Well, I understand. And I know that there's a notice issue. So I can tell you this, we're not going to get into that today other than the court's going to weigh in on it, because I do think it sounds to me like I know there's been motions to compel on both sides. There's a lot going on with this case just from reading your pleadings. and a lot of allegations. Both sides have a lot of allegations. And so I understand that both sides are going to want all the documents that they need in order to have the most effective opportunity to settle the case at mediation. So I get that there was a mediation canceled, and I know that may not have gone over well with the parties, but I understand from a judge's perspective, if one lawyer feels like they don't have all the documents they need to actually be able to look their client in the eye and say, look, I think this is going to be a good settlement for you, that mediation can be a waste of time and money. So we want to make sure when we go in and we mediate that we're going in with the best possible opportunity to get the case resolved. So I am going to, I can tell you, once we're done with the other motions, I am going to give you a mediation deadline, and I'm going to give you a trial setting. My guess is it probably is going to have to be moved from January the 20th, but I'm not going to do that until I hear a little bit more from y'all. But my guess is you're probably not going to be able to keep that January 20th trial date, but I'll give you a new trial date so that we all have an end in sight. Okay, so let's move on to the motions that we actually have that are set for the court today. Ms. Jones, I believe you filed your motion first. Is that correct?
I did, Your Honor.
All right, so we're going to proceed on your motion for audit first, and then Mr. Zachariah will come with your motions next.
Yes, Judge.
So anyone that's going to provide testimony, if you would, is this evidentiary at all, Ms. Jones?
I don't believe so, no.
Okay. All right. Then Ms. Jones, you may proceed on your motion.
Thank you, Your Honor. Okay. I'm going to ask Ms. Cook to put up exhibit number 1, Your Honor. And
All right, you may.
thank you. And Your Honor, what we've asked for is a motion to audit. And we don't want to appoint an auditor or pay any money to have an auditor appointed. We just want really Dr. Ahmed, the respondent, to tell us where this money has gone. And the reason that we're bringing this motion is because the money has, it seems like we have a moving target trying to get it done. And we have shown on exhibit number 1, and the only reason I put 2020's earnings there is just so the court can see it for sort of a, comparison type. I'm not asking that he account for those monies in 2020, because I'll remind the judge and ask the judge to take judicial notice that Dr. Jabin filed this petition February 25th, 2021. And so really anything that happened before 2021 certainly is a final issue, but anything that happened prior to the divorce, I don't need to have an accounting for. And what I'm asking for is Dr. Ahmed to go through and tell me where these funds have gone. You can see by the source on 2021, we're showing he has $502,000 from Lone Star, and that's exhibit number 5, and I'll publish that in a second. He has $220,000 from Critical Care Consultants. That's from his interrogatories, number 6, and I'll publish that in a second. And then the same with Mercy Healthcare System. He didn't tell us what he had earned per year in the interrogatories, but he indicated to us from Mercy Hospital, he has made $6,000. And so we times it. Also, we have a pay stub that goes through September 30th that shows he's had $65,592. And then the rental income, again, Your Honor, we don't have a yearly total on that, but by his interrogatories, he told us it was $17,000 per month. And so we took that amount and times it out to get the total amount of $975,000. And Your Honor, I don't want to quote you from what you said this morning, but I need to anyway. Remember when you told us you want the parties to have the best opportunity to get the case settled, the most efficient opportunity to settle at mediation. And if I take Dr. Jabin to mediation right now and not know where this $975,000 is gone, she's never going to settle. She's never going to feel comfortable settling. But if I can know where it's gone to, then I can tell her so much was paid for taxes, so much was paid for the mortgage on the rental income. On that rental income category of $187,000, all of that may have been paid out to mortgages, taxes, homeowners association. There may not be any net income there, but how would I know? And I can't ask Dr. Jabin to go to mediation and only to find out that, there's money missing. I'm going to scroll down on this exhibit now, Your Honor, because the next thing I wanted to show was when I met with Mr. Zachariah and we started going through the accounts, some of the accounts had been depleted. And you can see Chase account from 1700 as of the date of filing. February 25th, 21 was the filing. So the next day there was a balance of 371. And now there's a balance of 598, which is exhibit number 9. So again, I can't take Dr. Jabin to mediation and want her to settle without knowing where those funds went and without having a sworn accounting. I understand under the rules of civil procedure, under the rules, you can have an outside person do an audit, but I don't want to necessarily have the community have to pay for an accountant or an outside auditor. He knows where the money is and he knows where the money's gone. And so if he can give us a, statement that he swears to saying this is where the money is, and then I can go check and make sure that that money was really spent to that place, then we can take those missing funds and that missing income off of the inventory and the proposed property division. And additionally, Your Honor, I didn't unilaterally cancel this mediation. We found that he had bought 3 new real estate properties 4 days before the mediation date. He says he brought those with his separate property funds, but how do we know? There's been no tracing of those whatsoever. The money that he says is his separate property actually went into a community bank account, is so commingled, it's really hard to tell. And Ms. Cook, was it 3 or 4 properties that he brought right before mediation? 4? It was 4 properties, Your Honor. It doesn't matter. It was 3 or 4 real estate properties. And so you can imagine finding that out 3 days before mediation and then trying to go to mediation and tell Dr. Jabin that is really his separate property or it's not. I mean, he's under a standing order not to buy and spend and procure properties, and yet he's out there doing it. And this isn't the first time it's happened. So I actually filed a motion, Your Honor, to ask the court to allow me to reset mediation. Of course, we couldn't get it on the docket quick enough, and the date passed, but I wasn't just arbitrarily unilaterally doing it. I didn't want to pay, because remember, it's going to cost these parties $6,000 to $7,000 for 1 day of mediation per party. With our hourly rates and $1,800 to a mediator, it's going to cost them easily $6,000 to $7,000 to mediate this case per party. And why would I want to go and spend that kind of money when we don't have all the answers done? We don't know where this money's going to. And so I'm happy to go through these exhibits that are on here. I've already filed them, but I think you get the point that there is a lot of money that's at this time unaccounted for. Additionally, Your Honor, your court requires a financial information statement or a monthly, budget. And the husband has not done that, because if I could see a monthly budget from him and he had filled out the financial information statement, then we would know he's spending X amount per month. And I might be able to extrapolate backwards where the $975, $712 has gone to. But we don't have a financial information statement from him either. And I'm happy to go through these exhibits. I think it's sort of self-explanatory where I got these figures from. And there may be more monies. There may be additional.
I'd say this, because I'm live streaming. I've got the exhibits in front of me. So on the 1099s, W-2s, we don't need to publish those because we're live streaming.
Thank you. And then additionally, Your Honor, on exhibit number 9, that's his amended sworn inventory. And that inventory was filed as of June 18th. It has not been amended. And those new properties are not listed on here. They're not listed under separate property. They're not listed under community property. They're just not listed. And it's not like a bank account with $10 in it. It is real property that he is, purchased that is not on his inventory. I don't know how we could go to mediation without him filing an amended inventory, telling us those pieces of property, and then, answering the interrogatories why he thinks they're separate, since those monies were deposited. The claimed money, the so-called separate property was put into their bank account back in 2019 and 2020. And all the paychecks and everything's gone in there before. So there's been zero tracing of those new properties. So I'm asking the court to order him to do an audit to tell us where these funds went. And if there's any other funds that have come in that we don't know about yet, you know, to add those to the list and tell us what funds he's gotten, because the rental income, I may be incorrect on, Your Honor. Maybe he didn't have a tenant in January, February, March, and I just assumed from his interrogatory he's getting $17,000 a month from rental income times, you know, 11 months, and that's how I got my figure. But I may have double dipped because maybe he didn't have a tenant in there. But how would I know? I don't have any accounting of the tenants. And Your Honor, I think they have 13 pieces of real property. And so you can imagine trying to keep track of all of those if they're all rented out or a portion of them are. And so that makes it more difficult trying to find that accounting. So at this time, I'm asking the court to order an accounting of the funds that Dr. Ahmed has received in 2021 and give us a sworn accounting of those so that we can try to figure out what the estate has and where the money's gone. And I do think that the conduct of the respondent has demonstrated that an audit and an accounting is necessary, because I know you've heard 10,000 cases since we were last in here, Judge Bell, but the last time we were in here, he had bought property in violation of the standing injunction, and he had, there was more money, you know, outstanding. And he took $142,000, Your Honor, after this court signed the mutual temporary orders and after the standing mutual injunction was in place, and he took $142,000 out of their party's account to pay off the New Jersey home. And that's really frustrating to Dr. Jabin, because she may want more liquid cash. She may not want the New Jersey home and try to focus on running a New Jersey home when, you know, she's got, you know, twin children she's trying to take care of. So he is disposing of liquid funds and moving the money around that I think is in violation of the court order. The reason we haven't filed a motion for contempt or a motion for enforcement is we don't want any harm to come to him. We don't want any sanctions against him. We just want to know what the true community estate is. And so at this time, we are asking for Dr. Ahmed to account for the funds that he has received in 2021 and account for the withdrawals of the bank account.
All right, thank you, Ms. Jones. I have a quick question before I move to you, Mr. Zachariah, and it's for Ms. Jones. So I'm assuming at this point in the litigation that bank records have been exchanged. And so are you telling me that in the 2021, this 975,000 or so, have you been able to see that money was deposited into the accounts that you were provided in discovery, or that's not clear that money's been deposited?
The rental income, I have not been able to find all, and maybe it goes into a separate company and I just need to do more research. Some of the money is getting deposited into the various bank accounts. And so, yes, sir, I have been able to find out where some of the accounts are going to, but I don't have new bank statements. I think the last bank statements we got was August, etc. And so we'll probably need to, you know, just get current on those. But yes, sir, most of that money is in fact able to be deposited into the bank accounts.
Okay. Give me 1 second, lawyers. Just 1 second. We're going off the record. All right, I'm sorry about that. Mr. Zachary, you may proceed.
Thank you, Judge. Judge, are you able to hear me? I just want to make sure that I'm not speaking too slow or too.
You're coming in loud and clear. Thank you.
Thank you, Judge. First of all, Judge, I don't know if I've ever introduced Respondent Dr. Imtiaz to you. He's a pulmonologist. He runs a 52-bed ICU unit in Webster or south part of the town. And he basically works on shifts, and his income is flexible in the sense the more shift he runs, the more income he receives. And that's why you see the disparity between 2020 and 2021. Obviously, with the onset of COVID, he has been a frontline worker. He's been putting in 24-hour shifts, from what I understand, about twice a week. And then with all these variants coming in, it's been a difficult time for him. But at the same time, it's been financially rewarding. And thus you see the exhibit 1 that we just saw about the income that Dr. Imtiaz is receiving. Where we differ in this part, Your Honor, is that all the income that Dr. Imtiaz receives, whether it's from W-2, whether it's from 1099, or whether it's rental income, it's going to 3 bank accounts. And so all petitioner needs to do is look at 3 bank accounts and see what money is coming in and how it's going out. The first account that the money is being deposited in is actually managed by the petitioner. It's the account for the Easy Healthcare. That's the medical practice that the parties were running jointly prior to filing of this divorce. And we have a motion for access to the practice at this stage. But that's the account where all the 1099 income has been received. And so petitioner can clearly see that money coming in, and she can see exactly where that money is going. And actually, some of the monies that is being received as 1099 income is being used to pay the office rent, for the automobile that the petitioner is driving, for the malpractice insurance, for some of the other expenses of the practice itself. So the practice itself apparently is making sufficient money. Even then, the funds that Dr. Imtiaz is earning outside of the medical practice is being used to pay for the expenses. So I really am confused, and I don't know how to explain this further when petitioner says that she doesn't know where the funds are going. The second account where the money is going is Dr. Imtiaz's personal account, and all of those statements have been provided to Ms. Jones. I think the last
Have
statement.
account numbers, Your Honor. He has not given us account numbers on that Easy Healthcare or the personal account. It would help me to know the account or the last 4 digits.
Sure, this last 4 digits would be great.
Yeah. So Easy Healthcare is 0292. And actually, we are the ones complaining that petitioner has been taking money out of that account, and we have no idea where that money is going. From January 1st, 2020 till now, from what we can account for, about $222,000 have been taken out of that account. And we know that they're not for household expenses because Dr. Imtiaz is the one that has been paying these household expenses. The other account where the funds are going are 2131 and 0920. And then we have also provided for rent. All the funds are going to Zem Real Estate's account that is 1365. And we have provided the lease agreements. We have provided the closing documents for the properties. So I don't know how much easier we can make. Now, once we know what Dr. Imtiaz does, and once we know how much money he's earning, and once we know where those funds are going, and once we know how those funds are being withdrawn, I'm not sure why there's a reason or request even for audit. I don't know how much further Dr. Imtiaz can explain it. But having said that, we have responded to each and every interrogatory that has been propounded in this case, and every question that has been asked, we have answered. So nevertheless, if there's still a question outstanding, rather than filing a motion for audit, all the petitioner had to do was send a letter saying, hey, tell us where this money, and this money is going, like we did. Now, we heard respondent attorney state at least 5 different times that in March of 2021 or after filing of the divorce petition, respondent has purchased properties. But we have explained in discovery responses and even in this motion, the response that we filed, that the contract to purchase those properties was signed before this divorce petition was filed. So the parties had an obligation to close. And
I'm
if they
going to
hadn't
object,
closed-
Your Honor. That's a misstatement of evidence. We have properties in the last three we did not sign before February 25th.
I'm going to get to that,
2021.
Ms. Jones. I'm going
That's
to get to that.
incorrect testimony.
I'm talking about March
Overruled.
2021.
I'm going to give, hold on. Overruled. I'm going to give you an opportunity, Ms. Jones, to respond. So just make notes on anything you think is not accurate. It's just argument of counsel. Mr. Zachary, you may continue.
Yes, Judge. So the exhibit 1 that you saw where Ms. Jones showed that the balance in Chase 1700 was 371,000 and then it went down to 598. One of the reasons was that the respondent had signed contracts to purchase properties before this divorce petition was signed. I'm sorry, before this divorce petition was filed. So even after the filing of the petition, the contractual obligation to close still remained. And we have explained clearly in our responses to discovery, we have explained that in our responses to the motion for audit, and I can refer. And so it's not that the money went into a black hole. The cash was used to purchase real property. The real property was purchased on the basis of pre-existing contracts. And I don't really want to put up the bank statements and the contracts on screen, Judge, but if you have received our exhibits, then you can see the exhibits for themselves that we have shown the trail of these funds as to where they have gone. Now, the other issue that the petitioner has brought up today is that in September, I believe it's September of 2021, respondent used about 23 or 24,000 to sign earnest money contracts. Respondent has not purchased any properties in September of 2021. He has signed earnest money contract, but he signed the earnest money contract and paid the earnest money from the 25,000 that the court had partitioned back in June of 2021. Now, when the court signed the order partitioning 25,000 to each parties, petitioner took those funds, put it in a separate account. Respondent didn't. He kept it in the community account. But now in September of 2021, he took part of those 25,000, signed contracts, earnest money contracts, and used the funds that had been separated to pay the earnest money. And we have provided the earnest money contracts and we have provided documentation to that regard. So I don't know why there's still a mystery about it. Petitioner is also complaining about she doesn't know what rent is coming and what the lease agreements are, but we have provided all the lease agreements. The parties jointly own, I believe, 8 homes. Each of those homes, 11 homes. Out of those, 8 homes are on rent or the leases have been signed. And we have provided all of those lease agreements and we have provided all the bank statements that show that the rent income is coming into those accounts. And as a matter of fact, but for the production by respondent, the petitioner would not have been able to prepare the exhibit 1 and see how much money is coming in. So I don't know precisely what the mystery is. Now, we also have our motion for audit because—
Your Honor, before they start on their motion, I thought we were just going to do one. I do want to address that, but I just want to keep some semblance of order.
Yeah, I want to keep them separate. So we're gonna do Ms. Jones's motion first, and then Mr. Zachary will take up any motions you have set for today. All right,
Yes,
anything
Judge.
further, Mr. Zachariah?
not on this part, Your Honor.
All right, Ms. Jones, I'm going to give you a brief opportunity to respond to his arguments,
Thank you.
and I'll tell you my thoughts. Go ahead, Ms.
Your
Jones.
Honor, there's also money going into account 2920. There's also money going into account 3182. And then there's also an account 1721.31. Additionally, Your Honor, there's been money going to foreign bank transactions Bankers Bank and another one. And we've gotten some information on that as well. And Your Honor, when he brought those new houses, Dr. Ahmed wants you to believe that the earnest money contracts were signed before February 25th. So he had to go through them. Well, one, he didn't have to go through them. And two, by buying that many houses, it caused the New Jersey house to be paid off because he wasn't paying due attention. He had too many mortgages. They wouldn't allow that many mortgages. And so his wheeling and dealing and not listening and following the court standing injunctions and the temporary orders is causing the community estate to change. And I'm not saying at this time it has hurt Dr. Jabim, but it certainly can. Having to pay $194, it wiped out that account totally to pay off the New Jersey mortgage. And why did he get to decide which one was going to be paid off? He bought too many properties under the program, whether it was Fannie Mae or whoever it was, and it caused that New Jersey house note to be called. So he can sit here and tell you that he's only complying with the earnest money contracts and he has to do it, but it's not true. And it's not what I've seen in my 36 years of practice violating the, order. Additionally, Your Honor, he keeps telling you he's not purchased any property, that he signed earnest money contracts. And I think both you and I know that inception of title is when the earnest money contract is signed. And so I would have to beg to differ with Mr. Zachariah that he has purchased property, both right after the divorce was filed under those earnest money contracts. But then if that wasn't enough, purchasing those in March of 2021, he signs another 4 earnest money contracts in the fall of 2021. And that is against the violation. And it's hard to keep up with knowing where these funds are going. And so he indicated that these new houses were purchased with separate property, but it wasn't. It was taken out of a joint account. We don't see any tracing there. So I think that's the reason why we need to know. They say they've given us the lease agreements, but we're not getting the lease payments as they're coming in. We're not knowing where those are. And so to me, I would not have filed a motion and asked the court to help us get a inventory that's not a moving target, so that we know what we're dividing and we know how we're dividing. We think there's probably about a $5 million estate, but it's hard to tell because there's so much money going in and going out and, unaccounted for. So at this time, I do believe that there's been violations of the temporary orders and of the standing injunctions. I do believe money was spent without her knowledge. And I did say one thing in my motion to audit, that he had paid off the New Jersey house without Dr. Jabim's permission. And that's actually wrong. It's without her knowledge. I mean, of course, it's without her authorization or her consent, but she didn't even know. We didn't know until we got that bank account statement and saw that the account had been drained another $197,000 when it was originally $377,000, and now it's down to $598,000. And they don't tell us, they don't give us notice, they don't give us a choice of, which one to do. It's just unilaterally done it. And that's why we really came to the court today to say, hey, can you help us? Because even if we didn't settle at mediation, I think it would be hard for you or Judge Hepburn to sit there and figure out, when I say, here's $975, where did it go? I mean, it's going to be hard for a mediator, it's going to be hard for Dr. Jabim, and it's going to be hard for the court to know why these, accounts have gone down so much. And so at this time, I do think that he could help settle his case by helping account for where these funds have gone to and by completing a financial information statement.
Well, and I can tell you, I agree something needs to be done. I can tell you, normally my thought process on a situation like this is I don't normally require an accounting from one side. Normally my thought process is you go take his deposition, and first you give him a heads up and say, this money's missing, which you've clearly done. And then the burden shifts for him to explain where these funds have gone. And that's something that I would envision normally being done through discovery, either interrogatories or a deposition. But I can also tell you, I'm not a fan of buying properties during a divorce without the other side knowing about it. And I understand there was a partition of some funds, but if there's a partition of funds and you really want that property to be separate property, probably something you need to discuss with the other lawyer and say, hey, we didn't pull our 25 out of this community account. We want to pull it out now to purchase this separate property home. And then there can be agreements on that so that it's clear that it's separate property. Otherwise, we run into a potential for it to be community property, the presumption of community property. And then you're right, you're coming to court and you're rolling the dice as to whether or not it's going to be found to be separate or community. So it helps on large purchases in a divorce to consult with an attorney, have that attorney consult with the other attorney before a decision like that is made. And I understand some things move quickly when you want to jump on an opportunity, but it's a simple phone call to the lawyer and a phone call to the other lawyer so that at least everybody knows what's going on. And I understand if there were commitments, contractual commitments prior to the divorce being filed, I understand following through with those financial commitments. I'm more concerned with the earnest money contracts that were done recently, right before the mediation, or I don't know when they were exactly signed, but they were signed after the divorce was filed, after there was a standing order in place. That's not something that should be happening. That's not an ordinary purchase. That's something where it's a significant purchase that needs to be communicated to the other side. And if the other side won't agree on it, set up 5-10 minute hearing with the court. The court can authorize someone to purchase a property during a divorce, but it's not like it prior to the divorce being filed, where you're not under a microscope from a court's perspective on these financial decisions. And it does impact a community estate if someone pays off a $190,000 mortgage. You're taking liquid assets and moving it into something that's a lot less liquid. And so that's something a court can consider in making a property division. So those are things that are not ordinary living expenses. That's not, hey, this is what I do on a daily basis. It's a significant decision to pay off a $200,000 mortgage, and something that needs to be communicated between the lawyers on the case before it's done.
If I may, Your Honor.
I'm not gonna preach on this, because to me, it's, if there's an enforcement in front of me, I'll address that. But I can tell you, going forward, there shouldn't be any real estate purchases or mortgages paid off without the lawyers consulting with each other beforehand.
Yes, sir.
Now, that being said, this case is not going to settle when there's 1.35 million that's unaccounted for. So either it's got to be found out through a deposition where, and if there's sufficient bank records, that this money can be talked about on an intelligent basis from the lawyer to the party, then you may be okay doing it through a deposition. The problem I have is that's not an efficient way to do it. It's like pulling teeth, so to speak, for the lawyer to have to go in through thousands of pages of bank records for the course of a year. And it's not like this is just one bank account. It sounds like there's multiple accounts. There's a significant amount of income being generated, which is a good thing, but it also makes it harder for lawyers to do this on an efficient basis. And when you're paying lawyers $400 and $500 an hour, it doesn't make sense to make them be the ones that go in and trace out every single dime that has been spent and then question you about it. So my thought is, it probably makes sense in this case with what's been going on, that I have an accounting done by the respondent that just sets out where he thinks the money is gone. And you can use approximately what's on here. It may be that you don't agree with her numbers, but I want you to use approximately what's on here and just say, this is our best explanation for where the money is gone. And that needs to be sworn to, needs to be notarized. And then if that satisfies their concern on the other side, it may put that matter to rest. If it doesn't, then at that point, Ms. Jones, the burden's on you. You can take a deposition and we can spend resources to try to figure out more answers. And that's going to help the court in the event that it ends up having to come to the court, or it'll help a mediator get the case settled. But that to me is the way we're going to do it. So the motion for an accounting of where the funds have gone is granted. I'm going to give Dr. Imataz some time to do that, because it may take some time, and I understand both of these parties are doctors and very busy. You think, Mr. Zachariah, that that's something that could be done by, I can either do the 17th of December or the 31st of December?
Judge, I think I would need till December the 31st, given the holidays and some
fine.
travel plans that I have.
All right, so that accounting will be due by December 31st to Ms. Jones's office by say 5 p.m. that day.
Your Honor, will you please change the order that I've submitted? Because I don't think we put a date due on that order. I do have an envelope number that it came in on, if that helps. I just didn't put a date certain on when it was due. But I think other than you filling in that date, that order would be what you reflected.
Okay, let me look at it. You see that? The order on the audit.
Here,
Was
would
that
you like
filed
that?
this morning, Ms.
Yes.
Jones?
Would you want that envelope number?
Yes, that would help.
595-83743.
Did you get that or you need me to repeat it? She's getting that now.
Thank you, Your Honor.
And I can tell you while she's getting that order to both parties, I don't know if your client's here, Ms. Jones, or not, but
Yes.
what I'm trying to do as a judge is I'm really trying to maximize what goes in your wallets and not in lawyers' wallets and mediators' wallets. And that's the purpose of this order. I know I'm putting a burden on a party that, and this is not something that I typically do, but I think this will benefit both parties by doing it this way. And that's why I'm ruling the way I'm ruling. So it doesn't mean that I'm saying anybody's done anything wrong. I have given you my concerns about how we need to handle real estate transactions and mortgages in the future. But this is not me saying somebody's done anything wrong. This is just me looking at it as what's the most cost-effective way to get this case in a position where we can maybe get it settled, if not get it tried. It's 595-83743.
I'm sorry, Your Honor. I think there might have been a, can I repeat? 595-83743.
Correct. That's what we have.
Thank you.
I'm going to go ahead. We're still pulling that up, but she does have it. So I'm going to go ahead and move so we keep moving. Mr. Zachariah, let's address your motions. Do you have a preference on which one?
Yeah, Judge, I think if we can just go ahead and move to my motion for audit as well. And that way,
might agree to that. So if you'll let me speak for 2 minutes after he speaks, but before he does his motion, I might be able to save the court some time.
Well,
and
and I
short-
can tell you that I looked at the pleadings. I know it's about 250,000. It's a little less money, but more than likely the ruling would be the same.
But that's where I want to speak from, Your Honor. Most of that was pre-marriage. We're not asking for him to go back and account for things that were pre-marriage. These are things that she got from the company that are her paycheck. And up until February 25th of 2021, those are monies that they were living together, working together, doing it. You don't see any big expenditures there. I don't mind accounting for anything that happened after the date of divorce was filed. And that's closer to 99,000. You can see on his exhibits, 4 of those are to pay the business credit card. And I can have her testify that nothing from the personal thing goes on the business credit card. So I'm not sure why we would need to account for that. That ends up only being about $87,000 that she has received from the Easy Healthcare since this divorce was filed. And so I would object unless you're going to make him go back and account for what he did in 2020 with his money. I'm not sure why that would be as necessary. When they were living together, they had the same bank account, he had access. And so that would be my only disagreement on his motion to audit, is he's taken everything back from even January of 2020 requesting that we account for it. And I'm not really quite sure why that would be relevant or necessary. And like you had indicated, you would probably grant it because you granted the motion for him, but we only asked for 2021. And I would hope that the same thing. And so we'll agree to do an accounting for the funds that she had in 2021 and have no objections to proceeding on that.
Mr. Zachariah, is that acceptable to you that we only go back as the date of filing?
Yes, Judge, as long as it applies to both parties, it just saves a lot of time.
Yeah, it's going to be the same ruling. I mean, the court's going to be consistent on that. So they're going to have to provide an accounting as well. And we'll make that due same date, Ms. Jones, 12/31.
Yes,
Yours may be a little less extensive because it's less
But
money.
Your Honor, if I may have a
Yes.
minute,
You may.
it's not just that 222,000. In our motion, we have clearly laid out that petitioner has taken close to 400,000 that was not placed on her inventory initially when the court was making its.
I'm going to object, Your Honor.
About,
I'm going to object to relevance.
Your Honor, I'm just making my arguments.
No, let me do my objection. I have a right to legally object.
The objection
We
is
have-
relevance on what basis?
Relevance, and the reason why is, Your Honor, we have filed inventory since that time. A preliminary inventory that you filed when you're first in the case. When I filed that in May, I'd been on the case for literally 2 months and 3 days. We filed new ones. So him complaining that something wasn't on the original one that's now on the inventory makes zero sense to me and seems disingenuous. And I would object to relevance to anything that, predates.
All right, well, I'll sustain it as to it not being on the inventory. I understand it's on the inventory, but Mr. Zachariah, you may continue.
Thank you, Judge. Judge, I mean, you've already said what you're going to do. My point is that it's not just the 222,000 that we're complaining about. Petitioner had taken out close to 400 or 500,000 out of community funds and placed them in accounts that are under sole control, custody, and possession. So we want to make sure that the inventory is updated, all of these accounts are reflected, and any funds that have been withdrawn since the date of filing of this divorce is accounting for. That's all we're asking for, and that's all I was going to say. I did not say that this inventory was never updated, but there is a habit of not putting everything on paper and submitting it to us, and that's what has forced us to file this motion. That's all I have to say, Judge. Thank you.
All right, well, the ruling from the court is that we're going to go after the date of the divorce and that there'll be an accounting of monies that were withdrawn from or by wife, Dr. Jabin, and she needs to account for those just like I ordered Dr. Imataz to do. So it's a similar ruling. And Mr. Zachary, do you have a motion as well? I mean, an order as well, or do you need?
No,
me to-
Judge, I wasn't sure how you were gonna rule, but I'll be happy to file an order today.
Okay.
Or if the order that you have, you just want to change that to make it neutral.
Let me see. We got that. Okay.
I
Let
think
me
it'd be
look
better
at-
to have separate orders,
got
Your
the
Honor,
order
but
now. Let me look and see. Yeah, I'll take them all. Right, this is the order on the motion to compel. I need the order on the motion for audit. We're going to do them as separate motions.
Okay.
So, Mr. Zachary, I'm going to give you an entry date of 12/10. And if you'll just get that order in to me on or before 12/10, I'll sign it as soon as I get it. But the deadline will be the same deadline, 12/31 at 5 p.m. All right,
Thank
Mr.
you, Judge.
Zachary, let's move to your next motion.
Yes, Judge, I have a motion to modify temporary orders, and I believe I need to swear my client in.
Well, now on
I'm
this
going
one,
to ask,
I
Your
wanted
Honor,
to talk for a second. Go ahead, Ms. Jones, before
I
we.
was going to ask the court to consider a motion to quash on the temporary orders. And whenever you're ready for me to argue that before he starts, I would certainly appreciate it.
Well, I've reviewed the pleadings and I can tell you, the last thing I want to do is have a temporary order or motion to modify temporary orders if I'm a month and a half away from a final trial. But I've read the pleadings and it sounds like there was an agreement in a mediation that Dr. Matias would be able to see patients on Wednesdays at the clinic and that has been frustrated. Whether it's through someone's fault or it's innocent, I don't know. But it appears that, Mr. Zachary, am I correct? He's still wanting to see patients on Wednesdays?
At this stage, Judge, he doesn't. He just wants access so he can go and remove his degrees and some of his personal items from his own office.
So it's really what he wants to do is go into the facility and remove things that he needs to remove?
Yes, Judge.
All right, well, that sounds like something we can probably work out. Have y'all talked about this at all?
We have not, Your Honor, and I don't have a problem him moving
We
his stuff.
did.
I just need to know
Judge,
what he's
I
going to.
emailed her and I didn't get a
do.
response.
I'm sorry, I didn't mean to interrupt you. Your Honor, I just need to have a list of what he needs to move, but his diplomas, I don't have a problem. Those little things that he said, I just don't want her to go in. We're closing the business down. Under the MSA, the business is going to be closed down, and we need to figure that out ourselves. The attorneys have talked very, peripherally about closing the business down and how we do that. But she doesn't want to go to work on Monday and have all the examining beds gone. So we just really need to know exactly what he's going to take. And then he can come this weekend. We have no objections to him taking out his personal items and his diplomas and his files and the things that aren't going to affect him. But we're going to hopefully close the business down in the next 60 days. 60
Well, here's
to
my
90
thought.
days.
Here's my thought, just for efficiency purposes. Mr. Zachariah, you can have your client put together a list of what he wants to take out and submit that to Ms. Jones. And then I can give y'all a new date for the motion to modify temporary orders. If it doesn't get resolved or there's 6 things that y'all disagree with on the list or whatever, then I'm only dealing with those issues. I'm not dealing with, because right now I just don't think it's going to be really efficient for us to do that. If that's the intent of the motion is to just get him access, I'm going to give him access to the facility to get his degrees and to get some of the property out that he needs. That's given. That's going to happen. The issue is going to be if he wants to take, beds or imaging equipment or whatever they've got. Well, that might be an issue. If that's something they can't agree on, then that's something I'm going to have to weigh in on. But I'd rather be weighing in on 3 or 4 things than dealing with degrees and things that we know are gonna happen.
So,
But
Your Honor, if I may,
Okay.
I have already emailed Ms. Jones an outline of the items that Dr. Imtiaz wants to move. I'll be happy to send another letter to her explaining what it is. And it's not the beds, it's not any equipment, it's just personal items.
You don't need to send it again. If you've sent it, Ms. Jones, have you had a chance to review that with your client yet?
I have not had a chance to review it with my client, but I will. And it looked like when I glanced at it, there was nothing in there that was objectionable to us, or to me, I should say. But I have not spoken to her yet, and I will do that and have an answer back to Mr. Zachariah by this Friday at 5 p.m., if not sooner.
Well, what I was thinking I could do is, if you want, I can give y'all like a status conference, which you can pass if it gets worked out, but give you a status conference, and that way, if we need 5 or 10 minutes of the court's time to work on, 2 or 3 things, we can do that day. And it just gives y'all a deadline to make sure it gets done. So that's what we'll do. And I just remembered, because I'm one of those that I don't take vacation days, and I've gotten to the point where I'm losing them to the county when I don't take them. So I'm in December, and I'm having to take some vacation days so I don't just lose them. So the 9th and the 10th, I'm looking at taking those 2 days off. So actually what we're going to do, so it's not difficult on Judge Heppard, is I'm going to move your entry date, Mr. Zachariah and Ms. Jones. If I give you any entry dates, they're all going to be December the 8th. And so we're going to do a status conference on December the 8th at 9 a.m. I'm hoping that this motion for additional or modified temporary orders gets resolved. But if the list is not set by the 8th, then I'll want y'all to appear for entry, and we'll treat that as a status conference on the 8th, and I'll decide any issues I'll need to decide on the list. Okay.
And Your Honor, is there any way we could come in at 10 on the 8th, just because I have 2 temporary orders setting on that day at 9? Or could we do it maybe on the 9th?
Does the 8th?
Oh, you're off. You're off. Okay, I'm sorry. I'm
Mr.
sorry.
Zachariah?
I'm sorry, Judge.
Does the 8th at 10 o'clock work for you? I don't think we're going to need it. And if we do
I
need it,
neither.
I think it'll be 10 or 15 minutes. I don't think it'll be lengthy, but can you do 10 o'clock on the 8th?
Yes, Judge, I can.
All right,
Thank
I'll
you
do
very
that.
much, Your Honor.
We'll do 10 a.m. on 12/8. And again, I'm going to list it as a status conference / entry on my docket entry. But if y'all don't need it, then just copy the court or copy the other lawyer and send it to the coordinator and tell her you're passing, and I'll take y'all off.
Yes, Judge, but there are a few other items that we
Sure.
do want to address today
Okay.
in our motion to modify.
All right. And let's go ahead and swear your client in then. Sir, if you would, please raise your right hand to be sworn. Do you solemnly swear or affirm the testimony you're going to give in this call to be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, I do.
All right, Mr. Zachary, you may proceed.
Thank you, Judge. Can you state your name for the
Your
record?
Honor,
Sorry,
before
Ms. Jones, you had an issue?
I
preliminary
do,
issue?
Your Honor. I
What is that?
apologize. Lisa, may I have their motion to modify temporary orders? Thank you, Your Honor. On the motion to modify temporary orders, there are at this time not grounds to modify that. They have asked that the modification include a partition, and obviously a court cannot partition funds. They have asked for some other things that aren't allowed or authorized. Additionally, Your Honor, they're asking to modify the visitation, and he's not even using what he has now. Also, you heard Mr. Zacharias say that he was working 2 24-hour shifts a week. And so on the motion to modify temporary orders, I'd like to at least get an idea of what they're requesting, because many of these things, really the court is not authorized to do or cannot do. And so they're going into modified temporary orders when we would like to go to court January 20th, Your Honor, and we think we can be ready to go to court by January 20th. And so why are we going to modify temporary orders that are maybe 49 to 50 days away? And so had it not been for his new expenditures and new purchases and, paying off mortgage, we would have been, prepared and ready to go. So we at this time don't feel like the motion to modify temporary orders has any grounds to move forward. And on his pleading, if you look at the very, very last page, he talks about, he summarizes what he wants. And we can just tell you that, on the partition of $70,000 from each party from community assets, I don't think the court has any authority to partition any funds. Provide sworn inventory updated within 10 days. You know, I've been updating my inventory and probably have sent him at least 4 or 5. I know we did one on May 20, we did one April 8th, we did May 26th, we did August 14th.
Your Honor,
we did
do I
August
need to not
30th.
present my motion?
Well, it's sustained. Hold on. What I do need to know though is, Mr. Zachariah, since we've resolved a couple of the issues, what is it that you're seeking? Because I did have a concern, and it's actually in my notes on my docket, that why would I have a temporary orders hearing when I can just hear this once at final trial? So I want to know, what specific relief are you still seeking in the motion to modify temporary orders?
So Judge, I would start off, we talked about the access and we've discussed that, and the court has issued its guidance on it. We want to get expanded standard possession order. As I stated earlier in the hearing, Dr. Imtiaz is a pulmonologist, has had to pull a lot of shifts. We're asking the standard possession order to go in place beginning January 1st of 2022, because he will then be able to adjust his schedule and make sure that he's available to see his kids more often. What I'm confounded by and confused by is, on one hand, the petitioner is saying that they don't have enough information to even go to mediation. And then on the other hand, they're saying that they're ready to go to trial on January the 20th. Which is it? So I don't think we're going to trial for at least another 3 to 4 months. We've talked to mediators, and none of the mediators are available in December or January. The earliest mediator that we have found available is for February, which means we may not go to trial until March or April. And
I understand that, and I'm gonna weigh in on the trial thing at the very end.
Yes,
But
Judge.
let's assume that I'm gonna give you a limited hearing today on a motion to modify temporary orders. What specific relief are we requesting? I've got the possession and access. What other issues?
Judge, we want, the reason we want partition of 70,000 is because,
Objection, Your Honor. The court has no authority.
Sustained. Yeah, so I can't, if the parties agree to partition money, we can do that. So if y'all had an agreement that each party is going to pull 50 grand out of the estate, then I can bless that, but I can't just do that. So that's something that I would need y'all to agree on. And so I'm not going to deal with the partition. I understand why y'all may want to do that, but I don't have the authority to do that. So that's not going to be, I can't really do things until final trial as far as property division, other than sell certain things, award people exclusive use of it, but I don't have authority to partition it. So I can't do that. That's something y'all have to do by agreement.
so let me take a step back. Dr. Imtiaz has again an obligation to close on an earnest money contract that was signed back in October of 2020, which predates this lawsuit. That closing is coming up this month. And so we want the court's permission to proceed with the closing of the condos on Grant Parkway.
Objection, Your Honor. That's not a motion filed today.
Sustained. So based on my instructions today, y'all are going to need to file a motion to get permission to do that, because I can't do it through a partition, which is what's set for today. But
Your Honor, that request is separate from the partition itself. In my pleadings and in my request for relief, I've specifically said we want partition, plus we want permission to close. And I can refer you to the paragraph. Paragraph 19 and 20 of my motion, where we are asking the court to give permission to close and partition 70,000.
You know, I apologize. I have only seen in 19 that he's asking the court to set up a holding company using separate funds, and you would have to make a characterization midterm. You have no authority to make characterization of property unless there's a summary judgment in front of you. And so this would be improper.
Well, Judge, we're not suggesting that this holding company be characterized as either community or separate property now, but we do need to set up a holding company, and we do need to close based on a contractual obligation that arose pre-lawsuit. And that's why, as you stated earlier, that it's always good for the parties to come to court and get permission before doing a closing, and that's exactly what we're doing.
But Your Honor, nowhere in this motion does it ask for permission to close. And when was this contract signed?
October of 2020.
All right, so from what I can tell, just looking, or let me read 20. I read 19. Okay. I'm going to sustain the objection. I don't think that when is there a closing date set, Mr. Zachariah?
Yes, Judge, it's set for December the 15th is what I believe.
Okay, well, what I can say is that if we need to hear that can be set on the 8th at 10 o'clock, because I don't, this to me reads like I'm being asked to characterize property and partition property, and I'm, and order a holding company be set up. I'm not gonna do that. I can tell you that's something y'all are gonna have to trace that stuff and get that shored up prior to mediation and prior to trial date. And it may be you can do that and that becomes maybe something that y'all can resolve. But I am inclined, if it was a pre-divorce contractual obligation, this court's inclined to allow the parties to close on that. Assuming there's no harm to the community estate or no further, that it would be more harmful to the community estate not to close on it than it would be to close on it. So,
So Judge, the ramification would be loss of 129,000 in earnest money
right. So
to the community.
sounds like that's probably a pretty easy call for me. And maybe y'all, if y'all talk about it, y'all can work out allowing the close. But as far as partitioning or setting up holding companies, that's not something that I'm going to do.
We need to know how, sorry.
Well, I'm going to let y'all talk about that. It's not before me today, so I really don't. And I've got one more motion for enforcement I've got to hear. So and we're an hour and 6 minutes into an hour and a half announcement. So I'm trying to keep us on time. So my thought is I can deal with that on the 8th, Mr. Zachariah. You can put in your notice of hearing if there's a motion to sell real estate. I'm giving you authority to set that for 10 o'clock on December the 8th, and I'll hear that if I need to. But I've kind of given you all my thoughts on it. Ms. Jones, that doesn't mean I'm prejudging it. It just means if there's a big issue with closing on that after you get more information, just if he sets it, be prepared to address that on the 8th, and I'll make a decision after listening to both sides argue it. The possession and access I've got, the motion to sell we're going to deal with on the 8th. Any other issues that we need to address, Mr. Zachary?
Yes, Judge. So we want some of the household expenses, such as the rent for the office, such as insurance, such as car payment that the petitioner is driving to be shifted to petitioner, since the petitioner has been withdrawing more than $10,000 a month and really doesn't have much of a responsibility for household expenses.
All right. So my thought on that is, I understand the argument. I mean, I understand you wanting to have your day in court, but that's something that the court can factor in on a property division. And so I'm not going to reset this case for 6 months. This case needs to get to trial. But so I'm going to be giving it a pretty quick trial setting. I understand if one party pays the majority of the expenses or there's temporary support paid out, if that's an issue for the court and presented to the court, it's a factor that the court can consider. And so I'm not going to be modifying the payment of bills this close to a trial date. I am going to modify the possession and access more than likely, just because I think that's, but I'm going to let both sides argue that. But more than likely, if the gentleman wants a standard possession order, I understand you say he's not even exercising the time that he's given, but more than likely a standard possession order is coming unless there's some evidence that that wouldn't be in the children's best interest.
So then do you want to just take it up on December the 8th, Judge?
I think that that's a reasonable request. I'm going to let Ms. Jones argue in a second, but I'm
sorry, Your Honor. I wanted to have witnesses at the hearing on the motion to modify temporary orders. It's in the best interest of the child, and we can't do this haphazardly. Also, January 1st, if that's when he wants to modify it, then we're going to have maybe 30 or 40 or 40 days. I mean, that would be like 2 or 3 extra, Sunday overnights. And so why have a full-blown hearing when we're ready to go on January 20th? We'll be ready to go as long as they do their inventory as you requested. I'll have the information. But she is absolutely does not think it's in the best interest of the children. And so we want to have a full-blown hearing on it. And it just seems like I'll do it December 8th if you want me to, and I'll call my witnesses, but it's not even.
We're set today on a motion to modify temporary orders, and that's one of the.
Very well.
Yes,
So-
Judge.
Very well. I'll get him here. I mean, we can continue to go forward, but I need some time. You're going to need to give me 2 or 3 hours, Your Honor, because this is a very important issue. She thinks the children's welfare is a thing, and he's going to go first. He gets to testify first, and then she gets to testify second, and I'll get my other witnesses ready. I've got them on standby, but this cannot be done in 10 or 15 minutes. She's going to testify that these children are traumatized when, he brings them home early and doesn't show up, and he was out of town Saturday and didn't call them. And these children are a wreck. They should be in counseling. And so we need much more information on this. And we don't want to keep them from him, but we want him to use what time he has and what time he's been given.
Well, I can tell you that I'm going off y'all's time announcement. The court's not the one that set the time announcement. Y'all told me 30 minutes to an hour and a half, and we're an hour and 10 minutes in. So that's why I'm saying we've got about 20 minutes remaining.
And I think that's enough for me, Judge.
I can hear y'all. It's probably going to be this afternoon at 1:30 on for a longer period of time on a motion to modify the temporary orders, but I won't be doing a 3-hour hearing. I'm going to put a time limit on you, and it'll probably be each side gets 30 or 45 minutes. There's going to be a time limit that I will place on you because I don't see that it makes a lot of sense to have a 3-hour hearing when we're 2 months away potentially from a final trial. That just doesn't.
Your Honor, if I may, I have a conflict at 1:30. I'm ready to go now. And what I don't understand is petitioner's argument is that respondent is not spending enough time with the kids, so let's not give him time with the kids. I mean, that's a circular argument.
All right. Any other relief that you have on your motion to modify temporary orders other than the possession and access, Mr. Zachariah?
No, Judge, we've already talked about the others.
All right. You may call your first witness.
I'm going to call Dr. Imtiaz. Can you state your name for the record, please?
Imtiaz Ahmed.
Dr. Imtiaz, are you married to Seema Jabin?
Yes.
And you have 2 kids?
Yes.
And what are the names of the kids?
Xavier Ahmed and Isha.
And how
Keep
old
your
are they?
voice up. Keep your voice up, doctor, please.
15 years.
And they're twins, correct?
Yes.
Okay. And you're asking this court for a standard possession order, right?
That's right. I've been very busy with work over the last year and a half with COVID. I'm the medical director of the ICU. I manage a 56-bed ICU. Work
Can't
was
hear
tremendous.
it, Your Honor. I can't hear a thing.
It's coming in better now. I think they turned something happened, but it's coming in better.
So I was going to say, Your Honor, I'm the medical director of the ICU. When this divorce was filed, it was new to me and I did not know how much time I would be able to devote. So I did not ask for overnight stays. But now I am allowed only between 12 p.m. and 7 p.m., which is not enough with kids. I want to devote more time with them. They love time, spend time with them, with me. I can show you videos, photographs that we have done over the last 8 months since the filing of divorce. The time that they have to spend with me, they have enjoyed it thoroughly. We have been to Kima, Boardwalk, we have been to outings,
It's a
shopping.
narrative.
And yes,
Sustain. Wait for the next question.
okay. And I would,
Objection, Your Honor. No question on the floor.
Sustain.
So currently, you're only able to see the kids on Saturdays and Sundays,
correct,
and that's only on alternate weekends?
correct.
And what time on Saturdays are you allowed to see your kids on the alternate weekend?
I
12:30
can't
to
hear. I
7.
apologize, Your Honor. I just can't hear a thing he's saying.
Yeah, we're getting.
12:30 p.m. to 7 p.m.
Well, hold on. We're getting the witness in strongly now, and Mr. Zachary, we have lost your voice, so we're not hearing the question.
Yes, Judge, I'll try to speak even louder.
Okay,
Is that better?
it's better.
Okay, thank you, Judge. So you're only allowed to see the kids on alternate Saturdays from 12 to 7 p.m.?
Correct,
And you're only allowed to see the kids on Sundays from 12 to 7?
correct.
Okay,
Alternate Sunday.
and alternate Sundays. And do you want to spend more time with your kids?
Yes,
Why is that?
because I'm losing time on them. They're growing. They will be in college in 3 years. And I need to spend more time with them to have that connectivity as a father and my children.
And do you feel that spending just a few hours on Saturday, alternate Saturday, and spending just a few hours on alternative Sunday is creating a distance between you and your children?
Absolutely.
And can you describe that distance that you feel?
Well, I've seen my daughter, she just clings to me and will not let go when she's leaving my car. And she wants to spend more time. And I've spoken to them and they're very willing and very happy to be with daddy overnight on Saturdays and Sundays.
Objection, hearsay.
Sustain.
But you do not have the ability to have overtime with your kids. Is that correct?
Well, initially I was working weekends. I can, with the COVID settling down, I can spare myself on those 2 weekends and spend more time with my kids overnight and be with them all the time.
Now,
If my emergency duty calls in, I will have a sitter or somebody in place to take care of them. And they're 15 years old.
are you able to hear us, Judge?
Yes.
Other than going to Kima and some of the other things you described, what other activities have you engaged in with your kids on Saturdays or Sundays?
We go riding bikes, we go shopping, we go to movies, we go to restaurants, we eat. And then sometimes, with not having overnight stay, we have to rush and come back at 7 o'clock.
And if you come later than 7, is that a problem?
It's a problem with text messages receiving that you did not inform me and why you're late and this and that.
And who's sending you those text messages telling you?
My wife.
And that would be Petitioner Dr. Seema Jabin.
Correct.
Is that correct?
Correct.
Okay. And so do you think it's in the best interest of the children to spend more time with you?
Absolutely.
And you're asking this court for a standard possession order.
Yes.
Now, you said you are the director of an ICU unit. Are you able to better control your schedule beginning January 1st of 2022?
Yes, I can.
And how would you control your schedule?
I will take myself off on Saturdays and Sundays that I'm with the kids.
And you have that ability?
I make my schedule myself.
Okay. And what activities do you plan to do with the kids if they are with you overnight on alternate weekends?
We can go out of town, we can go camping when the weather gets better, things of that nature.
Judge, I'm going to pass the witness.
Ms. Jones, your witness.
You indicate that if you have an emergency duty call, that you would have a babysitter in place. Do you have any babysitters in place now?
I don't have it, but I can arrange it.
Okay. And how long would those babysitters be staying with the twin 15-year-old children?
Well, most of the time I will say if I have to go in, I have to work a day shift. I will perhaps work the day shift and be home by 8 o'clock. If that is not possible, then I'll have to have a babysitter stay with them overnight.
And
If I have to work a night
have
shift.
they ever spent the night over your house yet where you're
No.
living?
No,
And you say if you work the day shift, you'd be home by 8 a.m. But what time would you be
8
going
p.m.
in?
I'll
8
be
p.m.
going
What
at
time
7
would
in the morning.
okay. So they would be with the babysitter from 7 a.m. to 8 p.m., correct?
For day shift, perhaps not, because they live by themselves and they are living in their marital residence currently by themselves as well. They stay by themselves.
Objection, non-responsive. So
Sustained.
you would leave the children from 7 a.m. to 8 p.m. with a babysitter if you got called into a day's shift. Is that
Yes.
correct?
Yes,
Okay. And then if you had to work the night shift, that babysitter could stay overnight,
correct.
but you don't have any babysitter in place or that you
I will arrange that.
interview.
Yeah.
Objection,
I have resources.
non-responsive.
Sustained.
I have resources. I will arrange.
I will arrange it.
Okay, but you don't have anybody in mind.
I have multiple applicants in mind from care.com.
Okay, but you haven't interviewed anyone or you haven't procured a babysitter at this time.
I have not interviewed, but I have shortlisted them.
And why do you think it would be better for the children to stay with a babysitter overnight?
That is only in case
and
of
stay with their
emergency in
mother.
service of humanity
on.
and mankind.
Hold on. Wait for her to finish the question before you start answering it. I've got a
Okay.
machine that's taking down everything that we say, and it
Okay,
can't take down 2 people talking at the same time. So make sure she completes her question before you start to answer it. Ms. Jones,
Okay,
you may
Your Honor.
continue.
You said if there's an emergency and your duty calls you to come in, who would determine whether you have to go in on that emergency?
It is the need of the patient and lack of coverage at the hospital in the ICU.
You don't really have any control of whether you're going to be called in on an emergency, would you?
Well, I have colleagues who can replace me as well. So we have alternatives. And if it's only in a dire circumstances, that nobody is available, I'll be called. The chances of that is very, very bleak.
And you indicated that the night shift, the day shift 7 a.m. to 8 p.m. What would the night shift be if you got called in for the night shift?
It is 8 p.m. to 8 a.m. But usually, as I said, I will have arrangements with my colleagues taking over that night shift. I will try and stay at home with my kids.
How many times this last 6 months have you been called in to work?
Once.
Okay, and what time were you called in?
I was called in at about 4 p.m., 5 p.m. around that time to do the night shift because there was no coverage available and somebody had called in sick.
So you had got a call at 5 p.m. and you had to be at the hospital at 8 p.m., correct?
Right.
That's not a lot of time to arrange a sitter, is it?
If I had not the arrangements, when I had to go, I had to go. But of course, if a situation of that arises in future, I will have to exercise my judgment that my kids need me more than I'm needed at the hospital. So I'll have
Now
to
you
have
also-
alternate arrangements made at the hospital, my colleagues covering my shift or that
You also
vacant shift.
so indicated that you would leave the children home alone. Isn't that correct? You said you could leave
Well,
them home alone?
What I was trying to say that if there is a dire situation where there's a life in jeopardy and somebody is, going to die in the hospital because of me not being there, and it's my children at home, I would say, can a 15-year-old child or children stay at home for a couple of hours till I get back?
What about overnight?
And I
Would you
can
leave
take them
them
with me.
overnight?
I can take them with me in the hospital and they can be in the call room.
You would take them to hospital in the middle of COVID?
No, not COVID. It is my personal, physician's call room, which is very clean and separate.
Why would you take them to the hospital at 8 p.m. when they have to go to school in the morning? That makes no sense, Dr. Ahmed.
I'm talking about a Saturday night. You're talking about Saturday night.
But you've asked for Sunday return to school. Is that correct?
Well, Sunday return to school, Sunday will be off. It's only once in a while that had happened. And we are just trying to stick to that situation where it's a dire emergency that happens once in 6 months. And we are sticking to that. No, that's not the case. It is very, very bleak that it will happen. It will happen now that I have my kids with me, my hospital, my president, my CEO knows my situation. And he is going to help me with all kinds of help that he can provide in order to make me available at home.
But this has not happened up to this point, is it?
Well, I did not ask
Yes
for
or
it.
no?
Now I'm asking for it.
Yes or no?
What's
You've
the
not
question?
put your children as a priority first. You've worked a lot of hours. Isn't that true?
Because the hospital situation was that people were dying from COVID. I had to help them. I'm the medical director of the ICU.
Why don't you want to start till January 1st? Why wouldn't you want to see your children now? There's a whole month.
I have a travel plan coming up on the 20th of December.
Where are you traveling, sir?
I'm going to Pakistan to see my mother.
Okay. And so your vacation's more important than your children?
Objection,
mother.
argumentative, Your Honor.
Sustained.
Now, did you have Saturday visitation 2 weeks ago when you went out of town and did not tell the children?
I told the children and the flight was late. I told them that
Right.
I'll be with them. The flight was supposed to land at 12:30, landed at 6:30.
But why wouldn't you tell the mother, Dr. Jambeen, so she would know? Why would you just tell the children?
Children communicate with me very well and communicate with their mother very well as well.
So you never did contact Dr. Jabeen that you weren't going to visit that
I
day?
can't remember, but I think I did send that information in the joint text.
Look at your phone and show that joint text. Get that text out right now because you never text her, did you?
Objection,
your
Your
phone.
Honor, argumentative.
It's not
Overruled.
argumentative, Your Honor. It's showing that he's not telling the truth. He never notified this mother.
Hold on, I overrule the objection. He can
Please
that.
answer, sir. Why wouldn't you notify the mother and only the children?
I was at the airport. I was in the midst of, flight delays and stuff like that. I just, texted my children that I'll be late. My
But you
flight
didn't
got
even
canceled.
show up at all, did you?
I landed at 6:30 at the Bush Continental. By the time I came to Sugar Land, it was 7:30. My visitation ends at 7.
So did you see the children at all?
I didn't see children that week.
And you knew your children were extremely disappointed not knowing that you weren't
Well,
going to show up.
We covered up for that, and we spent more time and more quality time the next time I met with them, and they were okay with
How
that.
did you spend more quality time? Did Dr. Jabim allow that more quality time?
I utilized my own allocated time. No, she did not allow any extra time with me.
So you didn't really spend any extra time with them, did you?
I
Having
spent the
missed
same.
last Saturday.
I
Objection has been answered. He's already said she did not allow him to spend the time.
Prior to the divorce, what was the longest period of time you spent with your children without Dr. Jabim being present?
Objection, Your Honor. It's too vague, not specific. We don't know what time period is being discussed.
You say
I
time
couldn't
period?
hear.
Was it, did you say time period?
Yes, Judge, we don't know what time period.
Sustained. Let's just deal with like 2 years leading up to the divorce. Let's try that.
2 years leading up to the divorce, what was the longest period of time you spent with your children without Dr. Jabim being there?
she has girl parties and all of those things, her engagement. So I think
Objection, non-responsive.
7
Engagement party would have been many years ago, the last 2 years, sir.
last
Same.
2 years I've spent, I think at a stretch, 7-8 hours with them. Sometimes 10 hours, depending on what
Have you ever
Dr. Jabim's
spent the
engagement
night
has been.
with,
Objection,
you ever
Your Honor. I would request the court to allow the witness to answer his question completely before another question is asked.
Well, I think he answered it. He said up to 10 hours is the most.
how many nights have you spent with the children alone without Dr. Jabim being there in the last 2 years?
I think most of the time they have been with the family has been together. So I don't think there was any night that we spent alone.
After you guys separated, but before the divorce was filed, you never had them overnight, did you?
No.
How many times have you picked the children up late since March 2021?
5 minutes or 10 minutes late, most of the time on time.
But how many times you didn't answer the question? Hasn't it been 7 times you've been late to pick up the children?
It could be 5 to 6 times, but 5 minutes or 10 minutes, as I said.
You've also brought the children back early before 7 p.m., haven't you?
On their request that mom has to go to a party and we have to return early.
And then there's been times that Dr. Jabim has allowed you to visit the children in the marital residence, the one she's staying in. Isn't that true?
That is what was understood and agreed upon initially.
I have nothing further of this witness.
Mr. Zachariah, anything further from this witness?
Yes, Judge, couple of reasons, right? Why have the kids not stayed with you overnight since the filing of the divorce?
I never asked for it because of my schedule. I did not know how my schedule would work, but I wanted to.
But doesn't the MSA or the mediated settlement agreement provide that you shall not have overnight visitation?
Yes.
Okay. Now, coming back to it again, how many times in the last 6 months have you been called to the hospital in an emergency?
Once or
That's been
twice.
asked and answered once or twice.
Sustained.
It's actually, you know what, Your Honor, that's a different answer than he gave before.
I heard once before,
Yeah.
so.
Right, now he said once or twice.
Well, I mean, we don't have a calendar, Your Honor. He's going off by his memory.
My memory, yeah.
He's
Objection
under
to
oath.
Mr. Zachariah testifying.
I know, but he needs to answer from his memory, and if he doesn't know the answer, he needs to say he doesn't know the specific answer. 'Cause
Now, do you plan to work during the weekends after January 1st, 2022?
I will work on those weekends when I don't have the kids. On the weekend that I have the kids, I'll stay at home.
Will you be able to have another doctor cover your shift if there's an emergency?
Yes,
Now, you're going to Pakistan, is that correct?
that's right.
Okay. How long are you going to be in Pakistan?
About 15 days.
Okay, so it's a short trip.
Correct.
Okay. And in terms of babysitter, the reason you don't have a babysitter is because the kids aren't staying with you overnight. Is that correct?
Correct.
Now, do kids ever stay at home without Dr. Jabin by themselves?
They do.
Objection, that would be hearsay, that'd be speculative.
Sustained.
Have the kids ever? Never mind. How many visitations have you actually missed in the last 6 months?
Just one that I remember.
And was
That
that,
Saturday?
and that was because you missed the flight,
Not missed flight, the flight was delayed.
because the flight was delayed? Had the flight not been delayed, would you have visited the kids?
Absolutely.
Would you like to have seen the kids when you arrived at 7:30?
Well, I was not allowed to be there.
But would
after
you,
7.
but would
Yes.
you have liked to?
I would like to, and if I were allowed, I would spend a night with them. A little late till 10 PM or 11 PM, whatever allowed, keeping in view their schedule.
Now, you were asked, how much time have you spent with the kids without Dr. Jabin? Has Dr. Jabin taken any overnight trips
Not that I
in
know.
the last 2 years?
Not that I know.
Okay, so the reason you haven't been alone with the kids overnight is because you and Dr. Jabin lived in the same house prior to divorce, correct?
Correct.
So during the last 2 years, there was never an opportunity for you to be alone with the kids overnight because Dr. Jabin was always in the house as well, correct?
Objection, Your Honor. Leading, objection,
Sustained.
compound, and objection. He
But-
can
but
take them
I've
on
been with them
vacation.
alone when I
Objection,
worked
leading,
night
sustained.
shift and Dr.
Hold on,
Jabin.
sir.
Objection.
Sir, the- Sir, the objection was sustained. Wait for the next question.
Have you ever spent overnight time with the kids during the last 2 years?
Not overnight that I remember of, but I have spent multiple days when I'm
Objection,
back home.
non-responsive after, not overnight.
Sustained.
Have you spent extended period of time? Never mind. Your Honor, I'm gonna pass the witness.
All right, Ms. Jones, anything further from this witness?
No, Your Honor, I have nothing further.
All right, Mr. Zachary, any other witnesses you'd like to call on your motion to modify temporary orders?
No, Judge.
Ms. Jones, any witnesses that you'd like to call?
Yes, I would call Dr. Jabin. And I don't know if she's been sworn in, Your Honor. Were you?
He is not.
No.
Ma'am, if you
No,
would please
she's-
raise your right. Ma'am, if you would please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give in this call will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Speak up.
I
You need to keep your voice up because we got to be able to hear you. And the records got to be able to take down what you're saying. All right, you can put your hand down. Ms. Jones, you may proceed. I'm going to give about 15 minutes because that's about what the husband testified to. So let's be very efficient in our questioning. You may proceed.
You heard your husband testify that he missed one visitation. Do you recall that he missed 3 different visitations?
Yeah, I think it
Yep,
was,
yep. Yes.
yes.
Okay. Now, one time, where was he at when he called to tell you that he was not available to have the children?
One time he texted that he had to cover the hospital for the weekend, but actually he swapped his call to be at a party that was on the next weekend. So that
Objection,
was,
hearsay, Your Honor.
Sustained.
Who told you this? Who told you this?
because we have mutual, you
No,
know,
who told you this?
Dr. Yeah.
Would not be hearsay, Your Honor, because it's the party opponent. May she finish your answer?
I understand the rules. You're telling me, ma'am, I didn't hear it though. You said we had mutual friends. You're saying you learned this from your husband?
That he
This
was at the
information-
party.
He told you that?
What did he text you?
He texts me that he won't be able to because he has to cover the hospital on the weekend. But then he was at the party because we have mutual friends, you know, and when he goes to
Objection,
party.
hearsay, Your Honor.
Objection, hearsay, sustained.
Did you confront him about going to the party and not being with the children? Did you send him a text?
No,
Did he ever tell you why he wasn't able to visit that weekend while he was supposed to be at the hospital?
I think the most important thing is a communication problem because my goal is whatever is the best for kids. And there is a communication problem. And I've told him, I can show you those so many texts that I always tell him to communicate with me. He was out of town. I did not know that.
Good. 2 Saturdays
Objection,
ago,
non-responsive, Your Honor.
Sustained.
2 Saturdays ago, did he miss his visitation?
Yes,
Did he communicate with you and tell you he was going to miss the visitation?
no,
Did he ever text you, email you, or communicate with you in any way to let you know he would not be using his
he
visitation?
texted my son and my son had to ask him, why don't you communicate with mommy? She needs to know.
And do you know
Objection, hearsay, Your Honor.
Sustained.
approximately when the text came through or when the children knew that he was not going to exercise his visitation?
My son
Objection,
texted me-
hearsay, Your Honor.
It wouldn't be hearsay if she saw the text message, what time it came in.
You want
But
me
the
to
chief,
look
you haven't laid the foundation. for
Hold
it.
on, the objection's overruled. You may answer that, ma'am.
Approximately what time the text came in?
So at night time, my son asked, Daddy,
No, don't ask, talk about son. You have to just give us the time you knew that he wasn't going to visit the children. If you can answer it, you don't have to answer if you don't know.
I found out through my kids on Friday night.
Okay.
Because I had plans for Saturday that I had to cancel
Ma'am,
all
just
day
wait-
plan.
Ma'am, wait for the next question.
Did you have plans on Saturday to do something?
Yes,
And what happened with your plans?
I had to cancel because for me, I can cancel anything when it comes to my kids.
Have you ever left the children with the babysitter
So
in the last year?
I have never left. I never hired a babysitter because I don't want to leave my babies with any babysitter. That's why I choose to work in the office and not at the hospital.
Has he picked up the children late?
From house?
Yes, when he picks them up or when he comes over to visit at your
Most of
house.
the time he said Daddy's on his way. And then he's like.
Objection
15
hearsay,
minutes,
Your Honor.
20 minutes.
Well, hold on, ma'am. Don't tell me what the kids are telling you. And I need to hear what Dr. Imatiaz is telling you, but not what the kids are telling you. So the objection sustained at this time.
So pick up.
Wait. Sorry.
Sorry.
So has he picked up or has he come? Because he sometimes visits the children at your house. So has he come to the visitation late
Yes,
on one occasion or most of the time?
multiple occasions.
And he testified he was 5 minutes or so late. How late do you think he is on an average?
5 minutes to 20, 30 minutes.
Okay. And does he call you and let you know he's going to be 20 or 30 minutes late?
No,
Has he ever returned the children late to you after the period of possession has ended?
yes, there is no communication, what time they are coming back. One time they were supposed to come at 6:30, and then 7:30 I texted and asked kids, and kids say, oh, we
No.
Objection
Don't
hearsay,
tell
Your
us what the
Honor.
kids say.
Sustained.
Okay.
No. So when they were supposed to be home at what time? 7 p.m.?
Yeah, 6, because he has to go to his
Objection
shifts.
leading, Your Honor.
Has he ever brought the children home early
Yes,
on few or many occasions?
not many, maybe
Objection
few.
waived, Your Honor. I don't know what many means.
Overruled.
And when he comes late to pick them up, how does that affect your children?
I mean, they're just standing and asking Daddy.
Don't tell us what they said. Thank you.
They're just
Now-
ready, yeah.
Okay, now the time that he's not showed, you said there was 3 different times. Can you tell us how the children's demeanor was? Don't tell us anything they said, but how did they act? Were they happy, upset? What did they do?
I mean, they are upset because they know they have to do this. My kids are like, if they know they have to go somewhere, then they are ready for that.
Objection
Daddy-
hearsay, Your Honor.
Sustained.
Now, when he does not pick up the children, he's missed those visitations over the last 8 months. Who has to pick up the pieces and make it okay for the children?
Me, always.
Okay. And why do you think he shouldn't have any overnight visitation at this time?
Overnight, the thing is that Friday, they are coming back from school. They have the whole setup at home and they are doing homework. And Saturday, Sunday, they have activities. And right now, I don't think they are ready because this is end of the year and they are in high school, started high school, which is very stressful. They have all AP classes and they have other activities. So I'm the only one who is available to them emotionally because they are very close to me. They talk to me about
Objection
everything.
non-responsive, Your Honor.
Why do you think the kids are not ready to go overnight to their father's home? What do you think would happen? What are you concerned about?
I'm concerned about a lot of things, about maybe he has to go somewhere or they are with babysitter or they are eating dinner at time or they are sleeping on time, because I've been there for last 15 years, 24/7 with them. Even my full-time work, I've never had a babysitter.
Now, are you concerned about him taking him to the hospital?
Yes.
Why?
Because I don't want my kids to get exposed to any germs or hospital or COVID. I'm a physician. Why would I put my kids to be exposed to anything if they can peacefully stay with another parent who's who is with them 24/7. My routine these days is to drop them to school. Then I leave my office, pick from school, then drop home, then go back to office. I know how I manage that because I want to make life easy for them.
On Thursday, your husband is asking for him to have the children overnight and then take them to school Friday morning. Can you tell us if that would be healthy for the children at this time?
Not at all.
Why?
Because they have routine, they have tutor coming at home, they have the whole setup at home, study table, their books, everything, and they have to do homework, and I don't think they are mentally ready for that.
And can you tell me what day the tutor comes, please?
She comes every day. Sometimes she can miss a day, but usually it's every day, also Fridays.
Okay, so on Thursday, when they go to their dad's house, if the court granted this, would you have to cancel tutoring?
I don't know, because I haven't
I can
talked
pick
to
them
her.
off.
Okay, and then do you think that are you concerned about him getting him to school on time on Friday?
No, that's a concern.
Objection,
also.
speculation, Your Honor. There's no foundation laid for these questions.
Overruled. She can give her opinion. Ma'am, did you say you're concerned about him getting the children to school on time Friday?
Yeah, because let me tell you, the only time he dropped my son at the school was when actually a few weeks ago, my daughter Bunny died. So I had asked kids to let daddy come because they were very upset. He came inside the house, buried the bunny. And then my daughter, she didn't want to go to school. My son, he went with him, and then he took him to office doing his stuff. And then he got late for his class. He could have dropped him and then go to office, but I don't know why he took him to office.
That's wrong.
How late do you think he was to school this month when the father took him this one time?
So I think he was not counted tardy. So maybe he was surprised that he was not counted
That's
tardy.
okay. Can I ask you, how many times has the father of the children taken these children to school in the last 2 years? How many times has he taken to school? You just testified about one where he took your son late Thursday. How many other times has he taken the children to school?
Few times. I don't remember exactly last year.
Would you be concerned about him picking them up from school on Thursday when school releases?
Yes.
Why?
We might get late, and then he will know about their homework and other stuff. And because I know everything, every moment of their life, routine, activities. Let me give you example. Every time he come, he asks them, what time is your tennis?
Objection, Your Honor, narrative.
What time is this?
Okay, now can you explain, does the father know what time their tennis and extracurricular activities are?
Say it again.
Does the father know what time the children's tennis and extracurricular activities are?
I've told him so many times, but he still asks, is your tennis today? No,
Now,
he does not.
Objection, non-responsive.
What did the
Overruled. I
father
think
ask what did the father ask the children the last time he saw them about their tennis lessons in school?
Because he was asking that, can we go to have breakfast?
Objection,
on
hearsay.
Overruled. Did he ask you this, ma'am, or the children? Who told you this?
So for
Wait, just answer the judge's question. Who told you he wanted to take them to breakfast?
kids,
Okay, then don't
Objection,
testify.
Your Honor.
What day of the week was that he wanted to take the children to breakfast?
Saturday, which is their music and tennis day, and he already have been told 100 of times, but I don't know why he keep forgetting.
So he wanted to take them to breakfast Saturday morning, but they already had activities planned.
Yeah,
And if he has them over the weekend, do you think he'll take them to the music lessons and tennis lessons?
I don't know.
Do they enjoy their extracurricular activities?
Yes,
Are they very disciplined about attending?
yes,
Are you concerned that he may not continue their activities?
maybe.
And why do you say they're not mentally ready to spend the night with their father?
The thing is that
Objection,
when-
seek speculation, Your Honor.
Overruled. I'm gonna let her answer. You may
Can I
answer. Why do you think they're not mentally ready to go to their dad's house overnight?
Because initially because they need time to, go from Saturday, Sunday to the whole weekend and the night, because my daughter, she's 15, and in our culture, because we are Muslims, so girls are not, she cannot sleep in a room with daddy. We have some limitation when it comes to girls and boys.
Judge,
She sleeps with me.
she's giving a narrative answer, Judge.
And so I don't.
Sustain the narrative at this point. Ma'am, Ms. Jones, you may ask your next question.
Thank you. Do you think the children would adjust well spending Friday at 6 p.m. to Sunday at 6 p.m. with their father without gradually moving into that?
Gradually, yes.
Okay, but what do you think will happen if we don't do it gradually?
But then that will be stressful for them because they are not, I have talked to them.
Objection, speculation, Your Honor. She's not a psychiatrist.
Sustain.
I do a lot of psych in my primary care.
Is there any other reason that you think these children would not do well spending 2 overnights each weekend with their father? Anything else that you haven't already testified about?
No, I don't think so.
Thank you, Your Honor. We'll pass this witness at this time.
Mr. Zachary, any questions of this witness?
Just a few, Your Honor, with your permission. I'll make it quick. What is your work schedule, Ms. Jabin? I'm sorry, Dr. Jabin. I apologize.
So the reason I left the job and started practice so I can work with my
Objection,
my work-
non-responsive. What is your current work
Listen-
schedule?
Just listen to his question and only answer the question that's asked. He's asking what your current hours are at work.
My current hours is 9 to 5.
And what time do the kids get out of school?
I'll explain to you the whole process of pick and drop. So I drop kids, come back home, go to office, then leave my office at 2:45 to pick up kids and drop home and then go back to office. So I have a block of half an hour in my schedule. So my kids do not suffer because I'm working. And
Okay,
then I
I'm
come
going to
home
object
late.
to the last part as being non-responsive, Your
Sustain.
Honor. So there is a time frame during Monday through Friday where kids are left alone at home. Is that correct?
Yeah, if I have to go, I don't go back to work every day. It's usually Thursday and Tuesday. So I leave them home at 3:30, come back like 4:30, like for 1 hour. And that is the time. Yeah. So like one and a
Objection,
half hour.
non-responsive. Can you just answer yes or no? So there is a time period during which the kids are left alone at home. Is that correct?
Yeah.
I'm sorry?
Tutor is there. Their tutor is there. That's the time when the tutor come.
Okay. So you're not with your kids 24/7 then, are you?
Objection, argumentative, Your Honor. She's already
Sustain.
testified there at school and she's at work. I mean,
Your Honor, did you not testify earlier that you're with your kids 24/7?
24/7. If they're at school, I cannot be with them.
Okay. So then you are not.
But
with your
I'm a
kids
working
20
mother, so yeah.
So you're not with your kids 24/7. I just want to get that clear on the record. Your Honor, I couldn't hear the answer.
Yeah,
I'm
her
sorry.
answer was no, but it didn't come in very strong.
Yes, Judge.
No.
Now, has the tutor ever indicated to you, or is there any reason why the tutor cannot go to respondent's house if the kids are at the respondent's house?
objection, that would be hearsay. Has the tutor ever indicated to you?
Sustained.
We never
there
had
any-
this. Oh.
But I also said, is there a reason why you think the tutor cannot go to respondent's house should respondent have custody of the kids?
I don't know if she's gonna go because she's a girl and if she will be comfortable at his house, I don't know. Some tutors are not comfortable with a male in the house.
Do you have any specific reason for saying that this female tutor would not be comfortable in the respondent's house? Is there a specific reason for you to make that statement? Or are you just guessing? Speculating?
We're not hearing your answer, ma'am.
I'm not sure. I have not talked to her about this.
So then it's really speculation on your part, correct?
Yes, but
Okay, thank you. Now, has respondent ever asked that your daughter sleep in the same room as him in the last 2 years?
sorry, I didn't understand the question.
Has Dr. Imtiaz ever asked that his daughter sleep in the same room as him during the last 2 years? So then why did you testify earlier that your daughter cannot spend overnight with the respondent because she's a female and he's a male, although he's her father?
She sleeps with me. She sleeps in my room, in my bed, and she's been sleeping for last 2 years, every day. She doesn't want to
But-
sleep in her room.
Objection, speculation, Your Honor. We don't know
Sustained.
why.
And I don't want to traumatize him.
Do you know where Dr. Imtiaz is currently living? How many bedrooms are in that house? I'm sorry, we can't hear you.
3.
Okay, so there's sufficient room in Dr. Imtiaz's house to have a separate bedroom for his daughter, correct?
Yes, there are rooms, but are there furnitures?
Is it difficult to purchase furniture?
I don't know how much time it's gonna take for the whole setup.
So you're just speculating, correct?
No, I'm not. Because
We
he's
didn't hear
going
you.
out of country.
I'm gonna pass the witness, and I like Dr. Imtiaz to put on rebuttal for just one question, Your Honor.
Hold on just one second. Miss
Yes, Judge.
Jones, anything further from this witness?
No, Your Honor, that will be it.
All right, Mr. Zachariah, or I'm sorry, Miss Jones, any other witnesses you want to call?
Not at this time.
Mr. Zachariah, any rebuttal witnesses you want to call?
Yes, Judge, I'd like to call Dr. Imtiaz back.
All right, you may proceed.
Dr. Imtiaz, Dr. Jabin alluded to an event where the bunny died and you dropped your son off late to school. Do you recall that event? Can you tell us what happened?
I exactly recall that event. I received a phone call at 6:15 in the morning that the bunny had died. I understood that there was a problem with the mommy. They said Fluffy and mommy, and I was switching from the phone anyway. I ended up calling ambulance and police, and they all arrived at home, and then finally found out it was the bunny that had died. Long
So
story
let me-
short,
let
I
me-
picked up my
Hold on,
son.
hold on. So let me just clarify. So when you received the call, you thought that something had happened to Dr. Jabin,
Correct.
but that was a mistake on your part, correct? Okay. Then when you arrived at the house, what happened?
I went into the house, I saw that the bunny was dead. I picked up the bunny with my son and daughter and dug a grave and buried the bunny. It was dark. It was around 6:30 or 6:45 at that time, or maybe 7. Then I washed my hand and I got out of the house. My son came that, Daddy, I will go with you. And I dropped him to the school straight. I never went to any office or anywhere. He was on time. We went to the front office and he went to the class straight away.
Now, who pays for the extracurricular activities? of
It's
the
me.
kids?
Objection, relevancy.
Sustained.
So are you aware of the kids' schedule for extracurricular activities?
Yes, I am. I do confirm that, okay, what time? And that is what she was alluding to, that he does not remember. I'm confirming that, okay, the tennis class is at 1 p.m.
Okay, nothing further, Your Honor.
Ms. Jones, anything further from this witness?
No, sir.
All right, each lawyer can have about a minute for closing arguments on the motion to modify temporary orders. Mr. Zachariah, you may proceed.
Thank you, Judge. So the issue that the court has heard today is essentially on the audit, and I don't think I need to say anything further on that. The other issue that the court has heard is the standard possession order that we're seeking. Petitioner's entire argument is that respondent does not spend enough time with the kids, so therefore let's deprive him of any further time with the kids. We have to take into account all the facts and circumstances surrounding respondent and petitioner's life. And given that the COVID has upended the society and the life as we know it, and has upended his schedule, I think we have to take that into account. However, having said that, respondent has already testified that beginning January 1st, 2022, he will have a better schedule. He'll be able to have people, other doctors cover his shift. He's already talked to the superiors at the hospital who are willing to work with him on his schedule. Furthermore, during the last 6 months, there has been only one time where respondent has had to go to a hospital in an emergency. If you extrapolate, we're talking about going to the hospital in an emergency twice a year. I don't know if any given father during the course of a year does not have things that come up that are, emergencies. And we have to take into account that Dr. Imtiaz is not going on these emergencies as vacations or cruise to Bahamas. He's running to the hospital because a patient is dying and he just wants to fulfill his profession, but he also wants to see his kids, spend time with them, and do what's in the best interest of the kids.
Thank you, Mr. Zachariah. Ms. Jones?
Thank you, Your Honor. These children are 15 years of age, and I certainly would ask the court to interview the children in chambers before making a decision. Wouldn't they want to be heard? Wouldn't they want to know what, is going to happen to them? And to go from 12 p.m. to 7 p.m. twice, Saturday and Sunday to a standard possession order would be pretty much change. It'd be a huge change. And maybe we should ask them what would be important to them and what, considerations we want to take into place. Also, Your Honor, we would ask that if the father has to go to the hospital before calling a babysitter, allow mom to, take over that responsibility. Why leave him with a sitter when she's available, and especially overnight? Also taking him to the hospital. I'm not saying they can never go to his job, but we would like an injunction that, for the most part, he not take them to work when he has them, because that defeats the whole purpose. If he's at work and they're doing, something else in the doctor's lounge or et cetera, then he's not really with them. And so we would like some parameters on that as well.
Your Honor, he's not testified. That
Objection, Your Honor, that there's no more.
This is closing argument. Ms. Jones, you may continue.
Thank you. Additionally, Your Honor, I don't know if there's been any testimony for elections. So if the court's thinking of anything, hopefully it will just be some modified standard possession order that goes gradually for these children and not all at once. So at this point, since they've never spent a night with their father overnight in the last, 12 months, maybe we could start something a little smaller and work into it, or do some sort of stair step or gradual, just to make sure they're doing well and that it's not going to be traumatic for them. That's all I have, Your Honor, at this time.
Thank you. All right, the courts, well, let me ask, I got a couple of questions of Mr. Zachariah first. Sir, when you're on call for the hospital, is it a specific hospital or is it multiple hospitals?
It is two hospitals that I work in.
And which two hospitals are those?
These are UTMB Clear Lake campus, the University of Texas Medical Branch, and Hospital Corporation of America in Webster. They're just across to each other, across the street.
How far are those hospitals from your residence?
They're 42 miles away, but they're from each other. They're just 2 minutes away. They're opposite to each other.
The driving time for you to get there is what, 45 minutes to an hour?
About 45 minutes.
And how much advance notice do you get when you need to go in?
About 2-3 hours.
All right. And then last question, how far do you live from mom?
About 15 minutes.
Okay. All right, the court's
and if she's available, let me finish, Judge, if you permit me to. If she is available and she makes it easy on me, I will be happy to utilize her instead of a babysitter and leave the kids at home.
Well,
with her.
Part of my order, I'm going to give you my order, and then y'all can always work through stuff like that. But my order is as follows. Beginning January the 1st of 2022, Dad will have visitation with the children beginning at 6 p.m. on Friday, and it's going to end at 6 p.m. on Sunday. It's a transition. There's nothing that I heard that tells me I shouldn't do an expanded standard possession order, but these kids need to adjust. And right now, I do think mom has been doing like a lot of schoolwork with them and stuff. And that's not to say Dad can't do it as well. but I'm going to keep their Monday through Friday pretty intact for now. And then we'll ease into this, and then come final order, it may be that I expand this to a regular standard possession order, which would be Thursday night until Monday morning. But I want to ease them in and make sure everything goes smoothly with this. So beginning January 1st of 2022, the dad's possession will be pick up and drop off at mom's residence, Friday at 6 until Sunday at 6. On the Thursdays, is he currently exercising any Thursday visitation, Mr.
Judge, the
Zachariah?
MSA doesn't provide for that.
All right, Thursday, he'll also have 6 to 8 PM if he wants it, every Thursday during the school year. Additionally, Dad, you need to communicate any scheduling issues directly to mom, not through the
Okay.
children. I'm okay, they're 15-year-olds. So if you need to tell them you're running late, that can be on a group text saying, hey, dad's running 10 minutes late. But make sure mom's on that text. Mom needs to be the one that's communicated with primarily, not through the children, because kids forget to tell parents, and then that becomes a problem. And the burden is on the parents to communicate with the other parent, and I expect the parents to communicate with the other parent. So make sure mom's included on any notice provisions. If dad is getting a sitter, he needs to notify mom within a reasonable period of time prior to the sitter, and just let her know that there's a sitter. At least 30 minutes before, you need to let mom know that you're using a sitter. That way mom knows the children are being alone, and especially if it's an overnight. I don't know that that's ever going to happen, but I want a provision in here that says mom's to be notified at least 30 minutes prior to a sitter being utilized during dad's periods of possession. Additionally, if dad is unable to secure a sitter prior to leaving for an emergency, then you're ordered to surrender your children to mom's house on the way into the hospital. So they're not going to the hospital for visitation. If you can't get a sitter, I'm not going to let mom control whether or not you get a sitter or not. But if you can't get a sitter, I'd rather these kids be with mom than be at a hospital. So that's the ruling of the court. Mr. Zachariah, you'll draft into that order will be December the 8th with the other entries.
Yes, Judge. And Judge, can we include family visit usage by the petitioner and respondent to make it simpler?
Your Honor, that would be inappropriate after you've ruled to start adding new things to it. No, sir.
I didn't even hear the request. What was the request?
Can we add use of family visit by the parties to make it simpler?
No, I'm not going to do that. They may elect to do talkings, parents or our family wizard if they want to, but that's not part of my order today. That's something that I may end up doing on a final trial where y'all have more time to present evidence if there's issues like that. I do have issues with communication, mom not being notified. So that is something that would normally make me do in our family wizard or talking parents. But my hope is just my instructions today are going to fix that. And then we may not need to utilize a service like that.
Yes,
All right,
Judge.
thank you, lawyers. Y'all did a very good
Judge,
job.
you were going to give us a new trial date, or at least talk about that.
I am. That's the last thing I'm going to do.
Yes, Judge.
I do think you need a mediation deadline and a trial date. My thought is, I know, Ms. Jones, you think you can be ready by January the 20th. I personally think that's and I'm all about moving cases quickly, and felt that way as a lawyer. You just got to move cases. Otherwise they linger and then things just get worse, especially when you got a lot of purchases and stuff like that going on. We need to get this case to trial. My thought is a deadline for mediation would be February the 18th. And that I'll let y'all get the trial date, but I would set the trial date 30 days beyond, at least 30 days beyond that, so that y'all don't have to worry about supplementing in case it does settle. So the trial date would be the week of either March 21st, March 28th, or April the 4th.
Your Honor, I object to resetting this because it's not even on the docket at this point.
Well, no, I'm telling you, I don't think y'all can be ready by January the 20th.
Right, but can we deal with it once we have a motion for continuance? How do we know that? That pushes us way too out. And she's going to be on holiday for spring break with the children in Pakistan during that time. And so, I mean, that really does punish her when we're ready to go.
I'm not going to punish her. If she's got vacation, we're not going to schedule a trial when she's got vacation scheduled. It can be before then so if you get the accountings in by December 31st, you need time to review those and you need to supplement inventories. One other thing I'll say is if you make a purchase of a real estate, that's a basis for supplementing discovery and supplementing inventories. I don't hold people in contempt for not supplementing, bank records, because it's really, what does reasonable mean? It's hard sometimes to figure that out. But I can tell you, if there's a purchase of a real estate or a payoff of a mortgage, something like that, that triggers a supplementation from the court.
We've already supplemented.
And I get it. So, but y'all will need to get the inventories or the audits in by December 31st. Mediate, I don't know if y'all can get in with a mediator by January the 20th.
We've tried, Your Honor. We're not getting
Your Honor.
anybody
I've got
till February.
3 calls out right now that have some dates that are available.
All right, well, we're going to deal with this then on a different day. If y'all want to try to reschedule the trial date, then we can address that on the 8th if someone sets it. It's not set before me today, and I've got a motion for enforcement that's been itching to go. So
Yes, Judge.
I'm going to table the issue on the trial date. You're still set for trial January the 20th, and I'll take up arguments on that on a different day. All right.
May we be
Thank you, lawyers.
excused?
You may.
Thank you, Judge.
Turn off the record. All right, Mr. White and Miss Marino. Oh, Mr. White, you're having some with your
I
audio.
just noticed the chat that Miss Marino put a message in that she was. Yeah, can you hear me now?
I see, just starting a protective order hearing was, oh gosh, it just happened at 11:36. All right, what I'm going to do is I'll have y'all back at 1:30. I don't think I could finish y'all before lunch anyway. Hold on just one second.
Can you hear me now, Your Honor?
Yeah, that's better, but we got a little bit of an echo.
Yeah, I fixed it. I was having some connectivity issues
Okay, that's much
all
better.
morning.
Hang
So
up
my-
the other one, Jahi. You're on 2.
I think I'm on 1.
Well, you are. The other one's frozen up. I don't know if
Okay.
you may have disconnected and it's just not registering yet. So my thought is I'll have y'all come back at 1. I am going to hear y'all today. I know y'all got reset before because Miss Moreno had, I think, a protective order last time. So I will hear y'all today. I just, my guess is if I set y'all for 1:30, Miss Moreno can come in and can check in at 1:30 and we'll figure out where we're going to go. That other case, they had announced 30 minutes to an hour and a half and ended up taking an hour and 50 minutes. But it's hard to always estimate exactly how much time it's going to take. But Miss Moreno had a docket call at 10. And so I wanted to accommodate that other court with her as well. So we'll resume or we'll come back at 1:30 and I'll get y'all scheduled at that time. Okay.
Okay, Your Honor.
All right. Thank you all.
Okay, thank you.
Until 1:30. And Miss Benton, if you'll let Miss Moreno know that she needs to check in with the court at 1:30. It may be that she's still in the hearing, but she just needs to come check in with me so I can get an idea of what we're doing today.
Judge, I can hear, I'll check in.
Okay, Miss.
We're in testimony right now, but I can hear you.
Okay. All right. Thank you. We'll see you at
Thank you.
1:30.